is wide to extend the contravening the effect of the meaning of the scope void came up for consideration in a number of cases from 1951 to 1963, and been set out as was 8 to 14 in the case of compulsion. These judgments view worse such as morality, civil law, marriage, etc. Further observation made in some cases of the declaration of unconstitutional compliance with the law was never an existing law. However, in the several judgment decision in May 11, Supreme Court considered these earlier cases in para 11 and held that American decisions could not be relied to interpret Article 10. It was then held that the law of self-constitution would be inoperative and once placed in 1980 would assume full force of law. Because the earlier views were no longer valid. Earlier views of stillborn, etc., they said is not correct. It is submitted that the word void in 13.2 would only mean that the law becomes inoperative or ineffective once it is declared to unconstitutional. Such a law cannot be declared as void as it for the following reasons. As there is a presumption of constitutionality, till a law is declared to contravene the provisions of Part 3 or other constitutional limitations, it remains valid. The expression to the extent of contravention implies that there has to be a judicial declaration of contravention and the extent thereof. If such declaration is made, no law can be declared as void. If there is no entrance to the law has to be implemented, and all actions taken pending finally it will not become a law. The word void is used 14 times in the Constitution. The use of the word void in the context of the Constitution would be unlike the Compact Act, only means that a judicial declaration renders the law inoperative or unenforceable. The Oxford Dictionary defines the word void in 2 ways. As an adjective, it means that something is not valid or legally binding. And as a verb, it means to declare something is not valid. Use the word voided. A combined meaning of Article 249 or 251, read to 254, shows that the word void basically means invalid or inoperative. But I have taken this from a book by Justice S.K. of the Delhi High Court, who has discussed some of that. And then he refers to 249 and 250 and says, void will only mean invalid or inoperative, not void has been issued, still born, etc. G. The word void does not mean repeat. The judgment does not amend or alter the statute. It remains in the statute, but cannot be predicted. Article includes the express fundamental rights, but certainly derivative rights. Therefore, it will be incorrect to treat a constitutional unconstitutional law as void as an issue. Theory of second act. The constitutional declaring an administrative act as void is subject to several articles and discussion in the legal and other common law committees. It has been held that an administrative act will declare invalid continues to have legal effect. Actions taken while the law was declared invalid, till the law was declared invalid, would remain protected. This is popularly referred to as the theory of the second act. This has also been discussed in the landmark article Metaphysics of Nulity. The declaration of invalidity and the consequences that follow are two different aspects. In several cases, the courts have granted relief for taking actions during the pendency of litigation. But I have quoted 11 judgments where the courts have said, though it declared a particular provision to be invalid, since acts have been done, public interest involved, so we are not.
That option, Mr. Datar, is always open.
Correct.
It's not been done here now.
That's right. Now, the main thing is, suppose the court doesn't do it
In the wider context of what you said before this paragraph,
Yes.
how would you say it will operate if the principle, if a provision of law which is capable of criminal prosecution is declared null and void? Would you say it will preserve everything? Suppose there is a
Correct. Suppose there is a law which
reverse thing, it's a protective law.
Yes.
That's the prosecuting law.
Yes.
How will it emerge then?
No, and exactly. What these 11 cases say is depending on the facts and circumstances of the case. What is the nature of this
Today, we can't go into history of what should have been done in the judgment. We are today faced with the judgment.
Yes.
Constitutional Bengal. That be it. Are we required to go into these issues, or we'll have to construe it from point of view of that there was a law which was, as I said, at the cost of reputation, a law which was protective in nature and was struck down only on the grounds of arbitrariness because it sought to seclude some people from the protection while including other people from the protection. My concern is in this larger context in which what you are making a proposition, it can create reverse problems. If were we to agree with what you are saying here and preserve all acts done look at the reverse scenario.
No, I'm not saying it's a universal principle that it was always the acts done. Like, for example, I mentioned the case of 303 of IPC, where the Supreme Court struck down mandatory death sentences. Suppose the High Court had issued a sentence of making mandatory death sentence. Matter is pending an appeal to the Supreme Court. Meanwhile, the two judgment comes. They will say, sorry, on the date on which you were sentenced to death, that is the law, well, you can't help. And I'm not saying, I'm only saying that the whole difficulty arises is the argument is that once the law is void, it is void from beginning itself, and nothing survives on that. I'm saying that's not a law of universal right. And I'm sure not what I meant. What I'm saying is, I'm not canvassing the opposition. Fortunately, here there is no, it's not a binary. It will have to be molded, it will have to be molded depending on the nature of what is struck down. After it is struck down, what is the consequence? The reason why I'm giving these cases with the footnotes is the courts have gone into the question. We have struck down on subordinate legislation or struck down on statute. What is the effect of that?
Are we interpreting the judgment of Subramanian Swamy here?
No, what we are saying is Subramanian Swamy has to interpret it saying that the judgment will not have retrospective because of the protection under Article 23. That is the point. And we are now saying that the judgment cannot take away rights ex post facto, which the legislature cannot do because of the language of
To that extent,
yes.
I understand that.
Yes. Yes. So now the point is, what happens when a law is declared to be void? That is the question. Because since the Lordship is sitting in a five-year bench, and my lords in the High Court and the Supreme Court have occasion to frequently declare a particular statute as invalid or a subordinate legislation is invalid, what is the effect of that judgment? Because still today, except Vikram Nath, which is very goes to the context of 9th schedule in the context of Article 31B because of the language of 31B. Can we say that it's not necessary that every judgment is always retrospective? Every judgment always does not make it void from the beginning as an issue.
No, but did Mafatlal also deal
Yes, Mafatlal said.
with the context of tax statute there?
Correct. What Mafatlal said is that suppose a particular law is struck as invalid, only litigants who have actually challenged it can get the benefit of refund.
Correct.
They said that if
Past assessments will not get affected.
yes. And
Where they have attained finality.
yes. In fact, the Vodafone judgment also, which was retrospective from 1462, the moment the law was retrospectively amended, they issued a board circular of 500.
Where the suspensions are.
Suspensions are final, they will not be disturbed.
But that's on question of legislation.
Correct. No. Actually, you may say the circular is invalid, the section doesn't say so. But generally, the law is.
But that circular is in the context of the legislation.
Yes.
But Mafatlal specifically dealt with the situation.
Yes.
Where the assessments had concluded and with passage of time had attained finality.
Yes.
And even in NAFED matter, what was clarified where there was an amendment made in NAFED matter, it was clarified that the way where the principles of res judicata apply, those will not get affected by the legislation. That is a different context.
No, in fact, in taxation, your lordships from this epic chapter judgment, they say that where you have passed on the benefit, I am not to get the benefit because Article 26 ultimately is equitable relief. So in equity, I can strike down the law. But I may still say that since you have passed on, you will not get the benefit, the person was passed on the benefit. That's the law made for retrospective amendment. They amended 11B of the Central Excise Act. And now, almost all tax laws, the universal principle is if you have passed on the benefit, then you can't be unjustly enriched. So there is no problem. So to answer this question, I'm canvassing for the proposition that the court should not hold that the declaration of invalidity always operates from the beginning. It's not necessarily so. And the legal difficulty is best highlighted in one English judgment that I'll come to express the prediction more. But I'll go to the English judgment straight away. Please come to my compilation. Why I'm using in one page, the learned judge summarizes the difficulty which constitutional courts are going to face. He says, UK, you don't have that problem. But in countries where the courts can strike down the law, what is the problem? That he has. Now, the judgment starts at page 360. 370, sorry. Now, Lordship will just come to page 376. Just the first paragraph will show what is the controversy. Then I'll come to only that page. Read.
Just one.
from the statute, it continues there. Even if the Lordship sees B68, B68, 4 and 5 were declared to be violating the basic structure of mineral laws, but it is still there in our Constitution. NJC, struck down, still there in the Constitution. Now, Lordship will kindly see 197, page 197. On the right hand side, the amendment, reading in the top, the amendment of the Constitution which came later cannot be involved to validate an earlier legislation, which must be regarded as unconstitutional when it was passed. As Professor Cooley has stated in his work on constitutional limitations, the statute void for unconstitutionality is dead and cannot be vitalized by a subsequent amendment to the Constitution, removing the constitutional objection, but must be reenacted. We think that this is sound law, and our conclusion that legislation in question violates fundamental right of the appellants in the 1913, not protected by 1906, must be held to be void as against those. Now, this passage was subsequently found to be not correct. Then Lordship will come to the next case, which is the case of Behram, but I'll just come to Behram later. Please come to the next case, which is post Constitution 13. Which is NP Subraman. But I'll to save time, I'll straight away come to Deepchand. And Mahendralal Jain. Deepchand is 1959. And Lordship will kindly see. Mr. Subbarao goes into the discussion that it is stillborn. But Chief Justice Das makes the caution. Kindly start at page 274. PC para 3. Principle laid down by that. They say that the law doesn't violate Article 31. But now please see para 3 at page 274. In view of the aforesaid finding that the UP Act did not infringe the fundamental right guaranteed under Article 31, it is wholly unnecessary to discuss the following question, namely, whether the provisions of Part 3 inherent fundamental rights are mere checks or limitations on the legislative competence and the state legislatures read with the relevant entries in 7th schedule, or an integral part of the provisions defining, prescribing, conferring, so be whether doctrine of eclipse is applicable only to pre-constitution or can apply to post-constitution, which falls in Article 32. As however, our learned brother has sought fit to embark on a discussion, we desire to guard ourselves as being understood as accepting or accusing the conclusion that the doctrine of eclipse cannot apply to post-constitutional law. Post-constitutional law may infringe either a fundamental right conferred on citizens or on fundamental on citizens. In the first case, law will not stand in the way of the exercise by the citizen of fundamental right, and therefore will not have any operation of the rights of citizens, but it will be quite effective as regards non-citizens. In such a case, the fundamental right will pay citizens throw a shadow on the law, which is nevertheless in the statute book as a valid binding source. Now, Lord, come to the next page for 8 lines on the top. Whether a post-constitutional law of the other kind, which includes fundamental right, guaranteed to all persons, whether citizens or not, which therefore can have no operation of law, and whether it enacted is to be regarded as a stillborn law, as if it had not been enacted at all, therefore not such a document. It's a matter which we open discussion. On the finding right there, our discussion on these aspects do not call for a considered opinion and result. Nevertheless, not the majority of this Subara, they go and say it is completely stillborn, that is at para 13 and 14. The Lordship will kindly come where they say just come to just above para 14. But before I come to this above para 14, one point Lordship will kindly recommend is going to come to later. The Lordship will declare a law as unconstitutional on the ground of lack of legislative competence, not on the ground of fundamental lack of legislative competence. Lordship can also declare it as invalid, violating Part 3 or any other article, Article 286, 265, 301, Part 3. Is there a difference between these two laws which are applicable? In Bera Basic, the matter first came before 3 judges. And Justice Venkatramaya, he said that there is a difference. If a law is struck down for lack of legislative competence, it is void, it is a nullity. And even if you get competence later, you must re-enact the law. It is completely dead, it can't be sued. If a law is violating of Part 3, then it is not wiped out, it is still there. And if you remove the infirmity, it will become operative again. And this is the view taken by Venkatramaya and Bera Basic, about 3 judges. Because of there is a review of that judgment. And in the review, they posted before 5 judges. Before 5 judges, the 5 judges said there is no distinction between each kind of striking down. Whether you strike down for legislative competence or Part 3, both are the same. So it should have been taken and settled with Bera Basic that it was completely closed. Despite that, with due respect, in Sundaramaya's case, Venkatramaya once again takes it up and again reiterates that principle, saying that if it is legislative incompetence, the law is dead with reenactment. If it is fundamental rights, there is no reenactment, the law is there, you can always bring it to life later. Now, please see now in Subaraw's case at page 278. Now, Lordship writes, at page 277, just the highlighted portion of page 277. A distinction is sought to be made by the learned Advocate General between the law made in excess of the power conferred on the legislature and the relevant lists in 7th schedule, and that is violation of the provisions of Part 3. The former is suggested goes to the root of the legislative power, whereas the latter is said operates as a check on that power. With the result that the law so made is unenforceable. As soon as the check is removed, the law is resuscitated and becomes operative from the date the check is removed by the constitutional amendment. Then they refer to Mr. Nambiar's argument. Now, Lordship kindly. Yes. At page 278. Let's come to the highlight portion at 278. There is a clear distinction between the two clauses. Lordship has got it? Page 278. Yes. Under clause 1, a pre-constitutional law subsists except to the extent of inconsistency in the provisions of Part 3, whereas no post-constitutional law can be made contravening the provisions of Part 3, and therefore the law to that extent, though made as a nullity from its inception, of this clear distinction is borne in mind, much of the cloud race is dispelled. When clause 2 of Article 13 states in clear, ambiguous terms that no state shall make a law which takes away or abridges the rights conferred by Part 3, it will not avail to the state to contend either that the clause does not embody a curtailment of that power to legislate or impose only a check but not a prohibition. A constitutional prohibition against a state making laws cannot be written down by analogy or drawing inspiration from decisions of other constitutions, nor can we appreciate the argument that the word any law in the second line of 32 posits survival of the law made in the teeth of such provision. It is said that once a law can come into existence only when it is made, and therefore any law made in contravention of that clause, if suppose the law is not a nullity, argument is subtle but is not sound. The word any law in that clause can only mean act passed or made factually notwithstanding the provision. The result of such contravention is stated in that clause. The plain reading of this clause indicates without any reasonable doubt that the prohibition goes to the root of the matter and limits the state's power to make the law. The law made in spite of the prohibition is a stillborn law. Deep and Mahindra then use the word stillborn law. Now, I wanted to just point out where there is no distinction. Please come to page 201, where I am basic analysis. Page 201. Once the judgment starts, and note the benches, Justice Bhagwati, Justice Vikram Nath and Venkatramaya here. Now, here, the Lordship now comes to the judgment of Venkatramaya here. To that page 210. I regret I am unable to agree with the view of Learned to the Bhagavati. Then Lordship will write invalidity in two ways. One is lack of legislative competence, and the other is violation of fundamental rights. And there, please come to para 36. Lordship will quote para 36 at page 213. Another point of distinction noticed by American jurists between unconstitutionality arising by lack of legislative competence and that arising by reason of a check imposed on a competent legislature may also be mentioned. While a statute passed by legislature which had no competence cannot acquire validity when the legislature subsequently acquires competence, a statute which was within the competence of the legislature but which imposes a infringement of constitutional prohibition could be enforced proprio vigore when once the provision is removed. Law is thus stated by Willoughby. The validity of a statute is tested by the constitutional power of the legislature at the time of enactment by the legislature, and if thus tested, it is beyond legislative power. It is not rendered valid without reenactment later by constitutional amendment. The legislative power is granted. However, it has been held by where an act which is a general legislative power, but is rendered unconstitutional by reason of adventitious circumstance. For example, state legislature prevented so and so. The Federal Congress has already stated. Then there should be no regulation. That need not be reenacted, nor be enforced. Now, this was the Lordship is from page 216. Review is granted, and at page 270 is a bench of 5 judges. The Lordship now comes to para 11 at page 220. What is para 11 and 220? Para 11. We are also unable to endorse. We are also unable to endorse the opinion expressed by 11 to the Vikram that a declaration of unconstitutionality brought about by lack of legislative stands on a different footing from a declaration of unconstitutionality brought about by reason of abridgment of fundamental rights. We think that it is not a correct proposition that the constitutional provision is partly of our constitution, merely operate as a check on the exercise of legislative power. It's axiomatic that when the law-making power of a state is restricted by a written fundamental law, when any law enacted and opposed to that fundamental law is in excess of legislative power and thus a nullity, both these declarations unconstitutionally go to the root of the power, and there is no real distinction between them. They respect but two aspects of want of legislative power. The legislative power of Parliament and state is conferred by Article 245 and 246, stands curtailed by the fundamental rights chapter of our Constitution. A mere reference to provisions of 13(2) and 245 and 246 to indicate that there is no competency in Parliament is to make a law which comes into flash to those ones. This is clear from the mandate of. Now, so, the 5 judges said that there is no distinction between that. Unfortunately, despite that, in NP Sundaramaya's case, this Venkatramaya once again says that there is a difference. Now, Lordship will kindly see at page 237 the judgment starts. And if the Lordship now comes to page 258. Para 42 at page 258. Now, in considering the effect of unconstitutionality, it is necessary to remember unconstitutionality might arise because the law is not within competence or because. So, this is my humble submission, ought not to have been done. But anyway, my submission is this point is dealt with by later by Justice Matthew in 1974. He says, lack of legislative competences, you are restricted subject-wise, whereas in 13(2) you are restricted right-wise. Both are inhibitions against you. One is the inhibition where the subject matter. Article 245 to 246 says, sales tax, state government, income tax, and government. So that bar is subject-wise. Whereas 13 to the bar is right-wise, you will not violate constitutional fundamental rights or other provisions. Now, please come to the last Ambika judgment. Page 327. But very interestingly, for some reason, Article 19 is only for citizens. So if it's a company, you know, that most business is carried on by the company, there is no fundamental right to carry on business by the company. So some people suggest that you amend the Citizenship Act and say for the purpose of citizen can include a company. But that's why we make the company as a petitioner one, we make somebody else as a petitioner two after the Cooper and the DCM case. Now here what happened is, this is Matthew, Lordship kindly, his Lordship kindly come to page 334. What he says is, the particular labor law is violative of 19(1)G. It may be invalid to citizens, but it is perfectly valid to non-citizens. So, right to form an association if I prohibit a non-resident or a non-citizen from doing it, the law violating 19(1)D will be invalid to citizens, but perfectly valid to non-citizens. So, a law can exist invalid to citizens, but valid to non-citizens. And Lordship will just come to page 334. From para 28, his Lordship discusses the entire law. Just from para 28, his Lordship discusses. And now Lordship will kindly come to page 334 and yes. Now, kindly come to para 36.
Yeah.
Yes. If the meaning of the word what is 13(1) is the same as 32, it's difficult to understand why a pre-constitutional law which takes away abridges rights under 19 to remain operative even after the Constitution came into force as regards non-citizens, and the post-Constitution which takes the abridges inoperative respect non-citizens. The fact that pre-constitutional law was valid when enacted can afford no reason why it should be remain operative as respects non-citizens after the Constitution came into force, as it became brought on account of inconsistency with Part 3. Therefore, the real reason why it remains operative as against non-citizens is that it is void only to the extent of its inconsistency with the right conferred by 19, and its voidness is therefore confined to citizens as ex hypothesized. The law cannot be inconsistent with their fundamental rights alone. If that be so, we see no reason why a post-constitutional law which takes away or abridges the rights conferred by 19 should not be operative in regard to non-citizens, that is void only to the extent of contravention of rights conferred by citizens. Now, Article 13 is an injunction to the state not to pass any law which takes abridges fundamental rights. And the consequence of the contravention of the injunction is that law should be void to the extent of the contravention. The expression to the extent in the sub-article can only extend to the contravention of rights conferred on that part. Rights do not exist in vacuum. They must always exist in some person, natural or juridical. And under Part 3, they exist in fluctuating bodies like linguistic or religious minorities. And when the sub-article says the law will be void to the extent of contravention, it can only mention it means the extent of the contravention of rights conferred on persons, minorities, denomination, or religious community. Then Lord will kindly come to para 43. Please go to para 42 first. Mr. Wade has argued with considerable force that the terms void and voidable are inappropriate in the sphere of administrative law. According to him, there is no such thing as voidness in an absolute sense. So the whole question is void as against whom? And he cites the decision of Free Council in Duriya process. Now, this para 43 is important. In Jagannath was the authorized officer. The court has said that the Post-Constitution Act, which has been struck down for violating fundamental rights conferred under Part 3 and was therefore still born, has still an act existence without enactment for being put in the ninth schedule. That only illustrates that any statement under the law which takes away or abridges fundamental rights conferred under Part 3 is still born and null and void requires qualification in certain situations. Although the general rule that the statute declared unconstitutional is void at all times, and its nullity must be recognized and acknowledged for all purposes, and there is no law and nullity. This is neither universally nor absolutely true. So for the first time, after Jagannath, this is Matthew who just swearing and says, there is no universal nullity, there is no universal point that is. A realistic approach has been eroding the doctrine of nullity in all cases and for all purposes. And it has been held that such broad statement must be taken with some qualification that even an unconstitutional statute is an operative fact. It's an operative fact. At least prior to the determination of constitutionality. So, my lord, an unconstitutional statute is an operative fact at least prior to unconstitutionality and may have consequences which cannot be ignored. This is illustrated by source. So, my lord, the net result of this discussion, I am complete Jagannath, which is a 7 judgment. All these judgments are 5 judges. Keshav Mahadevan was 7. Then the next 7 judgments held Jagannath. And if your lordship now comes to this particular provision. Now, this case shows that a law which is struck down is not a nullity, is not obliterated. If it is stillborn, then it is dead from the beginning. But what this case says is, if a law is struck down, Parliament can always put it on the next schedule. So it will be paradoxical to say it is dead. And if it is dead, how can we put it in the next schedule? And that's what this court says, that don't use the word stillborn, don't go by American principles. Now, kindly see, my lord, here certain Madras laws were struck down, land reforms, and they put it in the next schedule. Now, for our purposes, lordship will kindly see. Please come to page 380. 18.
18.
Yes. They start with Beram Nisikaka, then again the 7 judges, not they discuss the entire law, right up to Sundaram, right? And lordship will now come to para 22 at page 3. In our view, although decision of the Sumerian Supreme Court and comments of well-known commentators like Willoughby and Cooley have great persuasive force, we need not interpret our constitution by too much reliance on them, nor is it necessary to scrutinize too closely the decision where the views appear to have been expressed that a law which is voided under 13(2) is to be treated as stillborn. Equally unfruitful would be to consider the doctrine of eclipse. Frankly, from my side as a student, I don't see why doctrine of eclipse should not operate to post constitutional laws. Suppose the Income Tax Act is struck down. I say beyond, say some sales tax laws are struck down and beyond, say, 1854. The Constitution is amended. Why can't it require life? I don't see. Now, but let me go further. Apart from the question as to whether fundamental rights originally enshrined in the Constitution are subject to amendatory process of 363, it must now be held that Article 31B and 9 will have cured the defect if any in the various acts mentioned in the said schedule as regards the Constitution has been alleged on the ground of infringement of fundamental rights. And by the express words of 31B, such curing of the defect took place with retrospective operation for the date on which the acts were first put to the statute. These acts, even if void or inoperative when they were enacted by reason of infringement of 13(2), assume full force and vigor from the respective dates of their enactment after the inclusion of the 9th schedule under the Article 31B. The state could not at any time cure any defect arising from the violation of Part 3. Therefore, the objection that the Madras sealing should have been re-enacted by the legislature after 70th Amendment cannot be accepted.
Mr. Datar,
Yes.
isn't this observation in light of Article 31B?
It is. No. But
Because Article 31D said retrospective. So really speaking, then it took away the theory of stillborn completely by legislation.
Correct.
By legislation, it negated that theory of stillborn. So therefore, the context in which the submission is made, the observation, the ratio is given, is in the context of Article 31 capital B.
Yes. Lord, I put it this way. Lordship knows the First Amendment was also retrospective because of the Lordship knows the history of 31B, etc. Now, 31B says that no law which is based on the ninth schedule shall ever to be deemed to have been void. So it gives life to that also. So no doubt about it. But the reason important of Jagannath is how do we interpret the law from Vikram Nath, Deep Chand, Mahendralal Jain, in the line of cases. Is the law nullity? Because if the lordship is going to hold it at 13.2, the declaration means the law is at nullity, then there is no law at all. Different consequences arise. I am using Jagannath to say that 7 judge bench has gone into the entire question and said all those 5 judges are referred to poorly and bellowly. But all the other judges are referred to American Constitution. 7 judges says don't interpret it on the basis of the Constitution, on the American. Secondly, I am submitting by analogy. Lordship is right. This is on 31B. But I can always take the benefit of the judgment and say, what is the meaning of this particular judgment? If you say a law is stillborn, that it is dead from the very birth, then even 31B can't give life to it. Because
there was something.
Because why I'm saying just one minute. The Supreme Court uses the word void or inoperative. They don't say stillborn. And my repeated endeavor to your Lordship is when your Lordship is sitting either in the High Court or in the Supreme Court, Lordship says Section 6 of the Excise Act is unconstitutional. It only means Section 6 becomes inoperative. It doesn't mean it's a nullity from the day the Act was actually made, 1944 or whenever. That's what I'm trying to say.
That's fine. But the issue, because here the issue was not. Therefore, directly the issue was not whether the earlier decisions, Mercy, etc., Mercy Kaka, was laying down the right ratio. That when a law is declared, suppose, like in this case, 66A is not being now brought in the 9th schedule, so what is the effect thereof? But really speaking, the net effect is whether you call it stillborn, ineffective, or whatever it is. It cannot be enforced.
And Mr. Datar, the further part says that very specifically. Same paragraph which you read, if you go down,
Yes.
it perhaps says what Brother and I say.
So, sorry, which part?
Paragraph 23.
Yes.
He stopped at
Lower
first part.
No, yes. What you will kindly see, these acts, even if void or inoperative, at the time when they were enacted by regional infringement, assumes the force and rigor from the respective dates of their enactment after their inclusion in the 9th schedule. So, suppose a law was made in 1966.
That's right. So
It was struck down.
it reiterates that on the date on which Act is enacted, it becomes void and inoperative. And only in one contingency where it is included in 9th schedule, read with 31B.
Yes.
And it is restored. And read your next sentence.
Yes. The state could not at any time cure any defect arising violation, and therefore objective and Madras seeking relief have been reenacted by the legislature cannot be accepted. Well, why this is important in the context of the line of cases is this.
No, but what it says is state could not at any time cure any defect arising from the violation of provisions of Part 3 of the Constitution.
Yes. What it means is, suppose your Lordship holds the law to be unconstitutional or not a violation of a particular constitutional provision, then it requires a constitutional amendment. Typically speaking, unless it's an Article 14 violation where the classification is bad, then you need not amend the Constitution. But suppose, like for example, in the case of Mandal, you hold a certain reservation can't cross 50%. Then you necessarily have to amend 16.4A and 15.4A and then make 15A more than 50% permissible, because then you are really amending what the Supreme Court has declared the constitutional interpretation.
No, what Supreme Court seems to be saying is
Yes.
that if it is declared as a void,
Yes.
being in violation of Part 3,
Yes.
it is void and inoperative from the date, but only in case where it is included in 9th schedule that it revives.
Yes.
But the law, as understood in earlier judgments, is retained.
No.
Court considers the contingency where it is put in 9th
No,
schedule.
in fact, with great respect, is just, when I say so with great respect, the petitioners argue that you can't put the matter into the 9th schedule because the earlier judgments have said the law is still gone, they are nullity, they are from the beginning, it's never there, it has to be reenacted. All those judgments are referred to from page 318 onwards. Then they say that in our view, because if the earlier judgment was there and if the law was held to be still gone, kindly see. Yeah, we need not scrutinize too closely the decision wherein views appear to have this particular still gone. The judgment would have gone further and said these all judgments are bad law. What I'm saying is, the Lordship kindly sees on page 318 onwards, is exactly what the departure they made. Lordship will kindly see, please see para 9. Para 9, very good, at page 318. On the first, the learned counsel's contention may be summarized as follows. Well, in fact, better your Lordship kindly sees the whole discussion. Response. Please come to para 17. The Lordship has got in the mean para 8. Yes. The Lordship kindly sees. No, I think Lordship will start at page 315 so that the whole thing is very clear. Now we have to decide whether the judgment really gets over the earlier judgment. Please see page 315. In all the above matters, there is a common attack on the validity of the Madras Land Reform Fixation of Ceiling Act. The Act received assent of President on 13th April was published in the Gazette on 2nd May. It was tried as so. Then Lordship will straight away come to scheme of the Act, etc. Now, please see Lord para 5. Para 5 at page 316. The Act was challenged by writ petitions filed in this court in 1963 on the ground that they violated 14/1932. The first attack was on section so of the Act taken on the ceiling, the second section 50 read with schedule 3. It was urged that the Act was not protected by Article 31A, relying on judgment of unique common interest. This court raised definition of artificial and resulted in discrimination between persons equally violating Article 14. This court also held the provisions contained in 50 read with second schedule were also discriminatory, and these two sections being pivotal positions, the whole Act is settled in the Constitution. The judgment was delivered on 9 March 64. It appears that similar attacks were made not only to our Madras Act, but to several acts of other states imposing ceiling limits on holding of land and attempting to effect agrarian reforms. To shield those acts, Parliament passed the Constitution's 17th Amendment Act on 28 June 1964. The statement shows the same. Then please see para 7. The 17th Amendment was itself challenged in Sajjan's. A number of petitions were filed under Article 32, challenging not only 17th Amendment but also 4th Amendment. So the first petition group of cases was filed by a group of persons against an order made by the Finance Commission of Punjab holding an area of 487 acres was surplus in the hands of petitioners under the provisions of Punjab security. 5 judges of the court held that all the amendments were valid, while 4 others concurred in the judgment delivered by Subara, holding that though the above amendment abridged the scope of fundamental rights, violating Article 13, they could not be struck down because of earlier decisions. One judge took the view that the fundamental rights outside amendatory process. Judgment in the Vikram Nath case was rendered on 70. In the meanwhile, a large number of writ petitions were filed in the Madras High Court in 64 and 65, challenging the validity of Madras Act, and the main attack was twofold. It was urged that the Act having been struck down by this court in special summary, it was honest and void ab initio, and Article 31B could not validate it without a separate validating Act being passed in the Madras legislature. And secondly, the Act was incompetent for want of legislative power. The second attack was leveled on a wide front before the Madras High Court. But before a Senate Council did not go so far to challenge the legislative competence. Now, this paragraph is important. On the first, Senate Council's contention may be summarized as follows. He urged that this court, having declared the Ceiling Act void under 13(2), we must proceed on the basis that the legislation was void ab initio, in as much as it did not lie within the power of the state to make any law which abridged the rights conferred by Part 3 of the Constitution. In other words, it was held that the measure was honest or stillborn, and any other validating measure could not still lie therein. It was argued that the effect of the Act being struck down by its court was as if it had been effaced from the statute, and to make any act operative, it was necessary not only to give protection against the violation of fundamental rights, as was sought to be done by 31B, but to get the state of Madras to re-enact the provisions of. Then a council drew our attention to several decisions in support of argument, we should take note. Then they started. So they take the basis of the argument.
Just see, paragraph 15, what was the argument of learned Attorney General, which was accepted? It was accepted only in light of language used by Article 31B.
Yes,
So this judgment really considers only in a different conspectus
yes,
that what is the effect of act being put in 9th schedule,
yes.
and that is because of language of 31B. If you see paragraph 15,
15, I'm coming to
paragraph 15.
On behalf of some of the respondents, the Attorney General of India argued that no reenactment necessary. Our attention was drawn to the wide scope of 31B, which sought to cure the defect of any in the acts specified in the 9th schedule, that any such act or provision was inconsistent or took away the provisions of so and so. The word 31 made it amply clear that it was sought to be not only prospectively but retrospectively. None of the acts shall be deemed to be void or ever to have become void on the ground of inconsistency mentioned. The removal of the defect was to happen, notwithstanding anything judgment accepted. In other words, this meant that if any defect had been subject matter to this court and any provision had to be void and constructed, such decree was to be inoperative. In effect, it was contended that the inclusion of the Act in the 9th schedule to the Constitution overrode and rectified all defects in the Act because of inconsistency of provisions with any fundamental rights of Part 3 as to the date of the Constitution, no matter what the defect. But that does not mean that the Act becomes stillborn. DC 31B.
Just 1 second. Here's the thing. If it is not put in 9th schedule, correct, the original
Going by your argument,
I was 31B.
leave 31B for the time being.
Yes.
Suppose 31B was not there. The defect pointed out, even in case of procedure, they say, suppose the legislation had rejected section 6A with retrospective by removing those clauses or saying we are removing this part altogether, or by removing the words offending word, applying it to other cases, all other cases, as though it may not happen. Let's forget about this case, it may not happen in this. But in another case, suppose on the ground of principles of national justice, a particular enactment is struck down and with retrospective effect, this provision is provided for the effect is taken. Obviously, it will require an amendment. It will require a new enactment. It will not be retrospective, otherwise it will be a huge problem. It will be, that's why, and 31B itself was not under challenge in this case.
No, 31B was uploaded in Sanjiv Khanna.
So it was not under.
No, I'm not. See, 31B is uploaded in Sanjiv Khanna. The government suggesting that Golak Khan, they struck it down again. Yes, not on that. But I'm only on the point that lordship declares the law is invalid. Is it stillborn? Is it nullity? For there I'm saying the earlier observations were found to be wanting in Jagannath's case, maybe in the context of 31B. Now, 2 points are making in 31B. 31B need not be where the act is struck down in the by a court and then put in the 9th schedule. There are many enactments, like so many land reform legislations, MRPT Act, so many acts. From the enactment itself, they put it into the 9th schedule. And that has been discussed fully in Koilo's case. What they say is Parliament can take a law and say this is meant for land reform and putting it in the ninth schedule. All the nationalization acts, or textile acts, straight away went to the ninth schedule. They were not gathered first and then went to the national. Straight in the ninth schedule. Also, MRTP have also put these elements of the ninth schedule. Now, what I'm submitting is, suppose the lordship tomorrow declares a certain provision of the income tax and invalid. I'm saying that section is not still on. Tomorrow they can again make a retrospective, invalidate it again. Because what they say has to be validated, enacted afresh. I'm saying it's not necessary to enact afresh. Just because we are only the question of by Subramanian Swami declaring 6 years.
That's not really relevant for us. How?
Correct. No. I'm only saying that my main argument is 20, which I have finished. I'm only saying the lordship is sitting, and this is all also with the question when you strike down the law, what is happening? Can we say the law is stillborn, void, ab initio, etc.? I'm saying those don't use those words stillborn, dead, etc. Say inoperative, ineffective. That is the proper terminology to use. Because when you say stillborn,
Let's not go into a hypothetical case because it will be
correct. So I'm only submitting. For the purpose of my argument, I need not get into all this, but since the lordship is
Once it is declared as ultra-virus invasion, all that is to be said is, in view of the provision B, it is struck down, that's all.
it is declared as invalid. It doesn't become void. Lordship will kindly see what Justice Deshpande points out. Void is absolute, whereas invalidity is relative, invalid to the extent of inconsistency. So, to answer your Lordship's question, if Subramanian Swami strikes down 6A, it need not necessarily become void ab initio. It will depend on the nature.
It's different. Therefore, I say it's a different thing. What you are saying is that, as I understand, subject to correction, the law no more exists on the statute book once it is struck down. Once it is struck down, it doesn't exist on the statute. Now, you may say it is omitted, it's not repealed, any of those provisions. But it doesn't exist on the statute book. Once it is omitted, it doesn't exist on the statute book. Now, there may be scenarios, to that limited extent we said, there may be scenarios where courts should proceed further. It may analyze what is the consequences of declaration in that law, that if it is not to operate, let us say, from day one, are there some consequences which need protection? Correct. To that limited, that's the reasoning which prevails. Sometimes the reasoning prevails that it should be prospective in effect. Why do you do it? Because prospective overruling is an accepted phenomenon. But you may not make it prospective, but yet there may be some nuances of it which the court can take into. The difficulty is how do we say what will happen in each scenario? All we can say is there are nuances which may arise, and the court should be, let me say, cognizant of the scenario.
Or ask consequential directions
And not necessary in all cases. If required, they may pass certain consequential directions. Only that much will arise. So it's normally the law doesn't exist after it is struck down. But there may be scenarios in which there may be prospective overruling. Similarly, there may be scenarios where the consequences may be taken care of. That's all.
No, I only was entering because when I did this research, I only wanted that this word to be born.
These are physiologies. Ultimately, you are playing with the English language in a sense. That's all that is happening.
But each word has got a dangerous connotation.
So it can have many connotations.
Nullity.
So then the interpretation, what does nullity mean? So these are interplay. The point is the law is, in a simple way, I would say the law is not on the statute book, whether it's omitted or anything. But since it held force of law for some time, if there are some consequential directions to be passed, the court will pass.
But one small even what the lordship said, I would only submit the lordship declare the law unconstitutional. It is not obligated and doesn't exist, but it is inoperative and ineffective. A provision in the statute, like for example, say the National Company Tribunal, it is there in the Companies Act amended in 2002. Lordship was pleased to they strike it out. The provisions are still there, but they can't be given effect anymore.
They have some chemicals. How is the provision still there after it is held to be implemented?
No, but
If the statute also, if you print print the act, will you print that provision? No.
Yes.
No.
No, very true. In fact, there is
All that will be written will be omitted.
No.
by this thing. Or there can be different kind. Or at the base of it, you will normally below that line, you will say this is how the provision stood at that particular
Exactly.
time.
No. What I'm submitting to your lordship is I get the authorities also on this point. If your lordship declares say section 42 of the income tax and the constitution, it is not obliterated. It will continue to be there, but it will be ineffective because to remove 42 from the statute book is a legislative act, and that has been decided by all Supreme Court itself. Because lordship see, for example, 368. Please see our constitution. Lordship 368.
So what you are saying is that
Omission and repeal is a legislative act.
at the base it will be said struck down as
Yes. But it will not be removed from the statute. Because that's the legislative act. And that's what many authorities also say, so that the effect of striking on the law, it doesn't mean, because right from Kishore, they say, striking on the law, a judicial act does not alter or amend the law. It only makes it inoperative. Lordship declares it to be void. Because under the power of judicial review, or Lordship under 226 or 32, Lordship can say this is ultra virus 14, ultra virus 16, ultra virus 19. But Lordship will see 368.
That's why that Pravati Vora case deal.
Lordship will say 368 of the Constitution.
yes.
Now, my Lord, Lordship will see 368 4 and 5. Please see that 3 and 4 and 5. No amendment of this Constitution, including provisions of Part 3, made or purporting to have been under this article, whether before or after the commencement of Section 55 of the Constitution, shall be called in question in any court on any ground. Then please see 5 for removal order hereby declare that there shall be no limitation whatever on the constitutional power of Parliament to amend by way of addition, relation, repeal to this Constitution. This is a footnote. My book says footnote 8. I don't know what Lordship note says. Inserted by Constitution, 42nd Amendment, clauses 4 and 5, which is inserted by Section 45 of the 55 of the 40th Amendment, have been declared invalid by Supreme Court.
Will it be same because Constitution being a different, will it be same for the Act also?
Same, it will be in the Act. It will just shown as held to be inoperative. Because what the authority says, once Parliament frames an Act of say 100 sections, the Lordship says strike down 6 of them. That will not have the effect of obliterating them. They will be inoperative. It will be dead for all practical purposes. Yes. So particularly in the book, when you print the Act again, it will be there with the qualified.
No.
No, but also, I mean, it's on this, when you declare a, because when all these cases were struck down, this concept of the theory of the second act was not there. What happens to the, because Lordship was under our Constitution, there is a presumption of constitutionality. If the act is declared to be unconstitutional, it continues to be valid. Now, when it becomes invalid, then Lordship has to qualify, because the Lordship rightly put it in all cases you can't say that the acts are saved. In all cases you can't say that acts are struck down. So what has to be done is my question. Now, in the case of 6A, what is the case of the law? Now, Lordship just come, I just read you the theory of second act, if the Lordship wants to bring it into our jurisprudence. Because inevitably, between the time of enactment and striking down, it is going to be living for some time, so to speak. That is going to be effective. Till your Lordship declares it to be inoperational or invalid. If the Lordship kindly comes to the theory of second act, please come to. I'll straight away take a Lordship to the book by Wade.
Mr. Datar, subject to correction, is it correct that this theory of second actor
Yes.
has been invoked only in cases where administrative action is held to be
Yes,
void?
because in England there is no other concept. Now the only thing is, there it's an administrative law, they can strike down a particular thing as invalid. An administrative order can be struck down, like subordinate legislation. Today, your lordship can strike down a primary legislation. I'm not doing the constitution basic structure, I'm just stopping at the level of parliamentary legislation. Now, in a situation where if there is a gap of say 7-8 years between the act coming into force and the act being struck down, how far will this period of nullity or effect apply? So there is it not necessary to bring in the concept, because lordship may say that depending on the facts and each circumstances, this will be a valid factor to be taken note of the case when it is striking down the law or giving consequential effect to the law. Suppose the law trade was in force for 10.5 years. Now just in my note, just some of the written submissions. Page 6 just come to a submission to the second act, why it becomes necessary. Last page, no?
Yes.
Prior approval for senior protection from 1969. The need for prior approval was initially contained in the single directive, which was in force from 1969 to 17/12/1997. After the decision, that's Philippe Narine. After the decision of Philippe Narine, the immunity was once again introduced by an ordinance from 25/8 to 27/10/1988. 6A was then enacted with effect from 11/9/2003, was implemented for 10.5 years till 5/5/2014, the date on which to declare unconstitutional by the Sound of the. Thereafter, Section 17A has been added to the Prevention of Corruption Act with effect 26/7/2018. Such immunity, that is prior approval, was deemed necessary to ensure proper administrative function of various officials. The continuous immunity further supports the need not to make the 214 judgment prospective in its operation. The reference may also be made to the recent judgment of the PMLA. In the PMLA, I don't want to cite it because it's subject to review. What the PMLA case says is that the section 45, which was held to be invalid, conditional bail, that by an amendment has again been brought into force. So they say that when the new section is again brought into force, it is as if it has effect all the time. Now there is a different context here. What it says, from 16 you got immunity. Therefore, these changes are really clarificatory in nature right from the beginning. They want to give immunity. What they have done in 17A, this classification of joint secretary have all been removed. All public servants get the protection. So the so-called discrimination which the court was found to be an infirmity violated of Part 3 has been removed. Now again, when you in 2014, except the small gap, when always they got the protection. And that also is a bearing on 21 because this immunity was a protection given to public servants from day one. And that immunity deserves protection under 20. So that has an impact on 20. And as far as 14 is concerned, if you say joint secretary, they said, all right, we thought that we will give it for people who are making decisions. But now we give it to everybody. So what is the LCM? Public officials will be protected. You can't straight away proceed against them, go to a police station and file an FIR and proceed against them. That's not enough. So now let's come to the theory of second actor. Why I'm submitting it? This is very important. Page 361. The passage from Wade starts at page 359. Now, Lordship, kindly see. Please see page 361, the famous passage from Lord Radcliffe, which we Lordship has seen a number of times. The first of these, an invalid act may not appear to be invalid, and persons who lack on the assumption are reading page 360 in the middle.
Yeah.
In a well-known passage, Lord Radcliffe said, an order, even if not made in good faith, is still an act capable of legal consequences. It bears no brand of invalidity upon its forehead. Unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset, it will remain as effective for its ostensible purpose as the most impeccable of orders. So, I would extend it as Justice spoke asked, what about English law? I'm saying Indian law, take it to the parliamentary law. Now, see, today we have this tribunals matter. Lordship has struck down the bench headed by Kishore struck down the provision saying it's not following Roger Matthew. Even after the judgment, the same law is reenacted, which is again subject matter of challenge. Now your Lordship strikes it down again. What happens to all those people who have been recruited and appointed as members of tribunal? Your Lordship can say that if you're going to make a law identical to the law struck down by the Supreme Court, will give no protection. You're doing it in the teeth of the Supreme Court judgment. Supreme Court judgment says you can't do ABC. In the law, you put I will do ABC. Then it's up to your Lordship to say no, I will not do protection to the laws. It could also happen that some law is challenged, and after 4 years, the people have been appointed, Lordship will say striking down, but people who have been recruited will not be disturbed. So this is what the point I'm making. Now, Lordship will kindly see the final point I wanted to make here. Lordship now comes to 2-3. Yes, Lordship will also read the theory of second act which I mentioned already, which is at 364. The theory of second act. An important step, 364.
Yes.
It's up to your Lordship to decide whether we should import it, because I am suggesting it's an important factor to your Lordship while striking down. Important step in developing a principled and practical approach to these conundrums. But the conundrum is, it is void in law, but actions have been taken. So what to do? Has been the development of the theory of the second actor. This theory, which has attracted significant judicial support, seeks to explain how an unlawful and void administrative act may nonetheless have legal effect. It is built on the perception that while unlawful acts, the first acts do not exist in law, they clearly exist in fact. Those unaware of their invalidity, second actors, may take decisions that act on the assumption that these first acts are valid. When this happens, the crucial question is whether these latter or second acts are valid. The theory of the second actor holds that the validity of these second acts does not depend on any presumption or validity or judicial exercise of a discretion to refuse a remedy to an applicant in particular proceedings. It depends on the legal powers of the second act. Did the second act have power to act even though the first act was invalid? Thus, in a case discussed above, etc. So the point is, so long as the first act is valid, the second actor, who is the person implementing the law, what is the protection he gets? Now, my Lord, last 2-3 judgments I just quote. Please come to where this court has, the Lordship comes to the index. I quoted from serial number 21, 22, 23, 24, where the courts have passed struck down a law but then protected the act done in the mean. So,
It can always be done.
yes. No, so just to say that when you declare a law, it doesn't mean it's a validity gone forever and ever. No. You can always, because the point is, what I'm trying to say in Jagannath's case is, if you say it's still gone validity, because it's not just a matter of semantics of words, each word has got a connotation. So the proper physiology should be, since the Lordship is taking a final judgment, when the court declares an act to be invalid, it is not still gone, it is not dead, it's not validity. It is invalid or ineffective, it is inoperative, that's all. And till it is declared ineffective, whatever has been done may have consequences which are actually negative. It can't simply be wiped off with a plot and say, all of this is gone completely. Now, Lordship will just come to go on real estate. Just 2 cases I'll point out.
And what property?
Yes, to say that where they and yet they said that
Mr. Datar, that is a separate question. You can always do so.
yes, I will give the para numbers, Lordship will speak. I won't trouble Lordship. Now, finally, not my subject is. Yes, yes. So if your Lordship has the time, Lord, I just put this 348. I included this very famous article which has been cited in a number of books. There was a festival in honor of Sir William Wade, and there is a book published called The Golden Metuan and the Crooked
And
Quad.
by that Porsit.
Posted. page 348, where for the first time they introduced the concept of they call it nullity. The law is invalid. It is invalid in law, but it is valid in fact. So it leads to some kind of conundrum, and this was discussed fully. Yes, because for example, physics.
Creates more conundrum.
Conundrum.
Even more conundrums.
Half will not be over. Ultimately, in fact, in the Lord Macmillan's trial book, they say that every case which comes to court is really a failure of the law. In that sense, because the law is very clear, there will be no case. That's another extreme view they take. So, my Lord, I'll just sum up my submission by submitting not this reference, which is taken up. Yes. No, I will just sum up my submission by saying that 6A, in a sense, is not just a mere procedural part, but is also substantive protection to the officer. It is entitled to the protection of 21. I would humbly request your Lordship to see the question raised by the Supreme Court of Constitutional Corporation, where they said that, look, don't read 21 just in a straight jacket way. Even the immunities, protections, and also should be read as part and parcel of it. I would further submit that 20 clause 1 should be read in harmony with 21, article 21. And the judgment in that Prabhudaya's case, which is Matthew's case, that the history of liberty is a history of procedure. And procedure is a bastion for, if you Lordship take that view in mind, it further strengthens the point that 6A is really a protection. It's a bastion for all civil servants from harassment, etc. And that protection was given. Was a protection entitled to the protection of 21, and the judgment cannot take away that protection. That on the other point I'm submitting is Article 14, and now I just address this point which spoke also related to this 31B. 31B doesn't make the law declared to be invalid. What it simply says is, even if a law is declared to be invalid, once you put it in the 9th schedule, it is deemed to be valid. The argument of the lawyers was that if it is stillborn, if you accept this theory of stillborn, etc., as per the administrative judgments, then where is the question of putting in the 9th schedule? There in paragraph 22, they say, please don't follow American case law. They expressly don't, in so many words, they said, we will not get into the stillborn issue at all. There is a law that has been struck down. It is still there, it is inoperative. It is modular, it is comatose. You put it into the 9th schedule, there which was inoperative, will acquire night proprio vigore is what they say in Jagannath says. So, to summarize the history of law from where I'm basing, my humble submission would be a declaration of unconstitutionality doesn't make the law nullity, dead, stillborn, those restrictions are no longer good law after Jagannath. We should use the word inoperative, ineffectual. And secondly, thirdly, there is no difference between striking a law for competence and this. Both have the same effect, it becomes unconstitutional. And my humble submission is, if the Lordship so feels, when the court declares a law to be unconstitutional, the court must also consider various factors which is quoted in the Goan case. How long was the law in existence? Who are the people affected? What is the public interest in the law? So the Lordship did not really let it go into those passages. Where they say all these factors must be kept in mind when you declare a law to be valid in consequential directions can be taken. And if the Lordship so believes with it, for the guidance of other high courts and other courts, all of us also, the declaration of unconstitutionality should normally consider whether the judgment should be, whether the law should be dead from the beginning itself, or it should protect what acts have been done in the interim. That's all I want.
Thank you.
So not a topic on which I was intending to address, but since it has.
You are for whom?
I'm sorry,
You are appearing for whom, Mr.
the same matter, okay, Mr. Bali. I was actually going to, we have divided the legal issue, but I just spent 3 minutes and not more.
Okay.
Because I've not got any judgment, but I just thought I'll make a few broad submissions.
I was discussing within the
Yeah,
concept of
this
2021.
21, and so on. Just a few moments on the request. The Lordship would see is that so far as the issue is concerned, the history of the law has been that public servants as a class, have been recognized as the class, have always received protection in the realm of criminal law. The protection in many ways is at three levels. One is at the stage of initiation of investigation. One is the conduct of the investigation by a superior officer, and then at the sanction level. So the underlying principle going back from 1800s, because the original provision for sanction was in the 1898 code, in fact in the 1872 code also. So what your lordship says is that the public servants as a class need a certain protection for the reason that have already been articulated in a series of judgments. Now the issue that came up in this matter was that whilst this particular protection was necessary for the public servants in the form of initiation of a prosecution, an issue of discrimination arose in the context of 6A. Vineet Narayan, you've already seen about the question of legislative competence. And in the context of 6A, there was not that the court intended to take away the fundamental protection that a provision such as 6A intended to give to the public servant. But it noticed a discrimination within the section that it protected only public servants of a certain seniority and did not protect the others. So there was an Article 21 protection to ensure protection for initiation of investigations against a public servant. When this was brought to the notice, all that your lordships have noticed is that it was struck down on the ground of discrimination, but not on the ground that this particular provision is not a provision that should be made available to a public servant at all. That protection was necessary, and that's held by a series of judgments of the court. So what your lordships have for your lordships today is a technical provision, argument and a ground on which 6A was struck down, but not on the substantive provisions of rights under Article 21. So because of this conundrum that your lordships now see, because in Swami's case, they said that on the ground of discrimination, 6A has been struck down. What happens to the larger protection that the legislature always intended to provide for public servants as a class? Therefore, when your lordship sees that all the types of protection at every level, and your lordships have upheld the protections for public servants, then should there not be a clarification that in relation to this particular aspect of the matter, where the protection is still necessary, and it has been reintroduced in 17A, that a need arises for a clarification. It's in that context, your lordship will just see paras 34 and 35 will go on. I think my learned friend was going to read it, but may I just point out, because when your lordships then deal with a situation of this type, where there is a 21 right, but for certain reasons, the court feels there's a need to strike it down. But there's a larger protection that's necessary. That's the protection that your lordship were referring to. And how do you deal with this conundrum that is now before your lordship? So your lordship will just see page 410, as your lordship is paras 34 and 35. What are the considerations in your lordship would render a judgment in a situation like this? And I'm not wanting to expand the scope to all cases. I think let's limit it to.
In fact, your argument makes me think, really speaking, whether this nature of protection given to a civil servant, this may be a statutory protection or protection under Article 21.
In fact, a lot of these are 21 protections.
No, may not be. If it is 21 protection, it will apply across to all citizens.
As a class
As a class apart. And that protection is inbuilt because investigation either by CBI or by the police is always considered to be and required to be independent, fair and transparent.
Right.
So that protection is the protection given under Article 21, which is applies across. This is basically a statutory protection given for a good reason. Given for a good reason. And the protection which is given in 6A is under the Delhi Special Police Establishment. It doesn't apply to investigation under the IPC or under the PC Act, whereas 17A is a protection now given under the PC Act.
But 6A,
And really speaking, where the cases of problem are arising, subject to what they say, would be the cases, what is the real effect of clause 2 or subsection 2, section 6A, because most of the cases, they would take the permission for investigation, etc., except in cases of subsection 2. Really, the dispute in most of the cases will be whether you fall under 2 or 1. It's in cases of where the department says you fall under 2, but the officer, public servant says, no, I fall under 1, that problem arises, and then that technical difficulty, because there is no approval of the central government, then the case is fought. That's the real, in practical terms, that's the real problem. Because otherwise they would, in most cases, they will not proceed. Being whether it's CBI or the state or the police, they will never proceed. But they are getting into difficulty when it comes to whether you fall under 1 or subsection 2.
What your lordship is 17 expanded the scope. It actually widened the scope from 6A. So while 6A was originally in the DSP, when they introduced it back in the Prevention of Corruption Act, they expanded it because all persons who can investigate a case under the Corruption Act are now subject to 17A.
Because really speaking, why should there be a distinction between a public servant and otherwise?
That's
Because
true that
all investigations are done by independent and specialized, where the state which is a representative of the person, that is the police or the CBI or any other authority, is independent. They're supposed to be fair and independent. Absolutely.
Your lordship, that's a larger question, but your lordship will see that history has been always to categorize public servants as a separate class and provide protection. So there have been a series of challenges to various levels of these protective provisions, and your lordship have repelled the challenge.
It's a administrative principle actually, that by the very nature of job they perform,
That's right.
there may be scenarios where there may be people who they may face something for doing their jobs which they should not.
That's right.
It's
It's essentially to save them from the harassment. That's where therefore constitutional challenges have been repelled to 197, 195. The whole series of provisions have been always repelled, saying that they are the class part. What happened in 6A was within 6A, the protection was only to a senior servant and not to a junior. And that was the discrimination that was noticed when 6A was struck aside. It was not for the purpose of not giving the protection to a public servant. And it is in that context the question arises that whilst your lordship has struck down 6A, should some clarification be issued, and therefore while dealing with it, 34 and 35 indicates that when your lordship are dealing with a provision like this, which is a protection, it's a fundamental protection to a public servant. That protection has been reintroduced in a wider form.
that in the beginning we said.
That your lordship has said. So therefore the question really was that how we deal with it. So therefore your lordship has said 34 and 35.
Thank you.
And then, and on 2021, I just had a slightly different perspective on 20, where I might say that 20 might be limited in its application to a conviction. And that last bit about immunity might extend itself to immunity from prosecution, which may be there under various provisions, either under the Constitution or under statute. So if there's an immunity from prosecution, then can there be an ex post law which takes away that immunity? So there could have been the issue of what is the meaning of immunity within the meaning of which is the term used in transcript. 20 might be only
Yes, now, sister, you will begin first, or?
No, I'm told, he wants to say something. But
I don't know what second stage.
I have no difficulty. He said he wants to say something. I may begin tomorrow.
No, who you are appearing, you will be addressing on behalf of
The central government, Union of India,
Mr. Raju.
not CBA. But substantially, we will not repeat anything. Our submissions would be over.
What we heard Mr. Kishore now got further. Mr. Kishore, what do you have to add further?
No, Mr. Datar has, the Learned Council has raised certain issues.
Actually, we have a scenario where all of you are on the same side practically.
So I wanted to offer a brief committee.
For a change, even the government is not largely on another side.
No, I essentially assist your lordship, without
No,
any.
I'm just saying.
Yes, sir, the lordships are right.
Of a counterpoint, there is no really counterpoint to.
Correct.
That's fine. I don't think anything. Yes, you may begin.
Can I begin tomorrow? That's all I'm saying. For 10 minutes, why?
How much time will you take?
I don't think more than a session, my lord. Maybe a few minutes more, my lord, thereafter. But it would be over tomorrow. I don't see any.
No, no. There will be difference between whether to keep matters for the half session or not.
I
thought you will not take more than half an hour, 45 minutes. Everything is said now. And you will be more or less, in assisting the court, will again be drawing on the principle of protecting the civil servants.
No, certainly. I will have to show, my lord, the distinction and, my lord, the myth which is created now. So kind of a protection is more rigorous protection under 17A. Another premise was
What an issue before us, really?
that has to,
Issue before us. The only issue before us is that
between 14 and 17, what will be the position? And, my lord, pre-14.
that
Pre-14, sorry.
there was a protection granted. That protection was struck down as discriminatory.
Not only on that ground, but we'll show that.
Legislature in its wisdom brings it back in a slightly different form. Having brought it back, what will be the scenario for the intermittent period? That's all that is there.
That's correct.
Okay.
But, my lord, I would request your lordship, my lord, not to have any sitting in the second half, my lord, so that we do not have that mental pressure of.
No. Certainly we want the mental pressure and all of you to.
Your lordship, your lordship may not have.
See, look at this way. We had scheduled 3 sessions for it, 3-hour session. I will abide by my 3-hour session. You must finish in the first half. Yes. Thank you.
Lord, your lordship would treat that provision to be mandatory and not directory. On the lighter side, at the end of
Everything is a particular way, but we all see. I keep saying only it's a mutual thing. We'll have to respect timing, all of us.
certainly. That doubtless.
To conclude matters, there is another set of matters. The 3 judges